American Society of Travel Advisors. Genevieve?
Yes.
And Donna?
Mm-hmm.
And Heather's not here.
There she is.
Oh. And on time.
And that's Henry.
I'm sorry?
That's Henry.
Ah. Hi.
Thank you.
Right. Good afternoon, Chairman Crespo. My name is Genevieve Strand. I'm the Director of Advocacy at the American Society of Travel Advisors. So I'm here today representing the almost 8,700 New Yorkers who work at travel agencies in the state. Thanks for taking the time to hold this hearing and for inviting us to speak to the impact of proposals addressing worker protections and classifications on our industry. In New York, the travel agency industry consists of 1,825 retail locations that contribute 8,693 full-time jobs and $717 million in direct economic impact to the state. These are predominantly small businesses, with 70% of them employing fewer than 5 people. So travel advisors, whether they're online, brick and mortar, or many hybrid business models in between, play a critical role in the broader travel and tourism industry. Well, the physical elements of travel include planes, trains, cars, hotels, cruises, tours. It's the travel advisor that pulls it together and makes it all happen. Like many other industries, travel agencies rely on the services of independent contractors. It's a business practice that provides substantial benefits for both workers and the agencies in situations where a traditional employment relationship is impractical. The use of independent advisors in our industry is prevalent and it's growing. According to our latest labor and compensation member survey, 75% of ASTA's member agencies reported engaging at least one IC, and of those who do, the average agency engaged 12. Compare this to 2006, when the average agency engaged only 4. All told, an estimated 20,000 ICs work in our industry. This is equivalent to about 20% of our industry's workforce. So there's a reason that this business practice is growing. These independent travel advisors are primarily women, they're all small business owners, and they're an integral part of the travel industry. But they're true entrepreneurs. They have the freedom to set their own hours, their own schedules, they set their own rates, they select the customers with whom they'll work, and they market under their own brands. So I think it's helpful to explain a little bit about how you would get started in our industry. There are a number of tools and systems that are required to get you started on the job. You need an ARC appointment to book air travel. You need access to a global distribution system, also known as a GDS, to search for travel inventory. You need back-end and mid-office systems, customer management systems, and more. Access to a lot of these systems is very costly. It requires time-consuming applications, even large bonds or financial certifications. So similar to the way that a real estate agent relies on a brokerage for access to the MLS and other tools, our advisors rely on host agencies to access these tools in a cost-effective and efficient manner. It allows these entrepreneurs to start their own businesses with ease and use the tools and support systems of the host agencies. It allows our travel advisors to focus on what they do best, sell travel. Unlike some of the large corporate entities in the so-called gig economy, upon whom most of the attention in these hearings is focused, the relationship between independent travel advisors and their host agencies is a mutually beneficial and healthy one. According to our research, more than 85% of independent travel advisors report being very satisfied with their current employment situation. The host agencies engage them, pay their fair share of taxes, and independent advisors make a decent living. The majority of independent advisors work less than 40 hours a week, but still 3 out of 8 earn more than $50,000 annually. Proposals to implement the so-called ABC test, like Assembly Bill 5 in California, put this system, which is beneficial to agencies and independent advisors alike, at great risk. According to our survey data, if a change in law would require ICs to become employees, more than 60% of independent advisors would choose to leave the industry or leave the state altogether for one that allows them the flexibility they currently have. As you examine the various legislative proposals that aim to extend labor rights and protections to gig economy workers in New York State, we believe it's critical that they be amended to clearly state that workers engaged to sell travel in our industry be evaluated under the current standard in place in New York for many years. When AB 5 was passed in California, travel advisors received an exemption along with numerous other industries such as insurance agents, physicians, dentists, direct salespersons, real estate agents, barbers, architects, and others. We feel strongly that if New York is to follow California in adopting an ABC test, the travel advisor should be exempt here as well. California recognized that a one-size-fits-all solution was not the answer, and we hope that New York will recognize that too. Thanks for considering our views on this critical issue. As you consider the various legislative proposals before the committee this year and next, we'd welcome the opportunity to work with you and your staff on ways to preserve the IC model that has existed in our industry for decades and provides opportunities for thousands of small business owners. Thank you for your time, and I look forward to answering any questions you may have.
Good afternoon, Chairman Crespo. My name is Donna Liquori. I'm a freelance journalist and writer based near Albany. With me is Heather Heddleson, an Ulster County resident and work-at-home mother. She's here today with her son, Henry, as you see, to represent online educators working as independent contractors. We are here to express concerns about legislation that would reclassify independent contractors. While no one is disputing the intent, the proposed legislation protecting workers from being exploited, the current proposed bills would have devastating ramifications for those of us who choose freelance work and are not being targeted by the companies this legislation is intended to address. We represent the group New York Freelancers concerned about Senate Bill 6699A and Assembly Bill 8721A. There are 400 members of us in New York. There's another group in New Jersey as well as fighting this legislation. Many of our New Jersey cohorts are independent contractors and freelancers with companies based in New York City. We are the creative economy, but we are also many other professions. Our New York group includes freelance writers, journalists, teachers, translators, marketing professionals, photographers, graphic artists, realtors, truck drivers, artists, drivers, entrepreneurs, actors, voiceover actors, and more. And we're all scared. We're afraid that not only are we going to lose our livelihoods, but also lose the work that we love. Just to give you a sense of the economic impact, in September, the New York City Mayor's Office of Media and Entertainment released a Freelancing in New York study. That reveals that 1 in 3 New York City workers, or 1.3 million people, have freelanced in the past year. That means the economic implication is $31.4 billion in a year, according to the study. The study also says that 46% of recent grads are entering the job market as freelancers, and 2/3 of freelancers cite a higher level of job satisfaction than non-freelancers. Many of the people in our group are also parents, particularly working mothers, like Heather and myself. We perform contract work, online teaching, translation services, writing, and editing to stay rooted in the workforce while caring for our children and to bring in much-needed income. Some of our children require special care or education, and this allows us parents the flexibility to meet these needs. Many of us prefer simply to be our own bosses and work independently, a choice that we make as professionals. As a freelancer, I am able to drive my daughter to a special school an hour away and work remotely in libraries, coffee shops, and co-working facilities. It works for me professionally and for my family. As it is written, this legislation would impact my work, particularly the work I do as a journalist. I'd like to point out that the American Society of Journalists and Authors, which endorses the guarantees of free speech and an unfettered press established in the First Amendment to the Constitution of the United States, unquote, has denounced these bills, opposing these, quote, legislative efforts to restrict the ability of independent writers to work as they choose without governmental interference. The organization stands in solidarity with our members and with all freelancers facing threats to their livelihoods as a result of laws and legislation aimed at either prohibiting or restricting their work as independent entrepreneurs. In my work as a journalist, I would not be able to satisfy at least one of the components of the so-called ABC test that is included in these measures. Part B, or 2, states, the person performs work that is outside the usual course of the hiring entity's business. So as a journalist, I would not be able to work for news organizations, which have staff writers. I think there is some expectation that news organizations would hire freelancers under this legislation. However, as you're probably aware, from 2008 to 2018, the news industry has declined by 25%, according to the Pew Research Center. Thank you for your time and letting me voice my concerns. And I will turn this over to Heather now, and she will tell you about her situation.
Thank you. Chairman Crespo, thank you for the opportunity to be here. I'm Heather Heddleson. I've been an independent contractor working specifically with a company based in China for 1 year. Currently, there are about 28 online ESL language companies open to U.S. citizens. The notification of today's hearing read, quote, "It has become clear that many workers within the gig economy continue to experience low and unstable earnings, lack important worker protections and benefits, and often face dangerous health and safety hazards on the job," unquote. These comments are broad generalizations of the gig economy and do not accurately reflect the conditions of many workers. Online educators like those that teach English as a second language to students across the globe are often paid twice the New York State minimum wage, work from the comfort of their own home, and have autonomy in their scheduling. Many are stay-at-home mothers working to supplement their household income, or working mothers supplementing their traditional employment wages. I'd like to point out that similar legislation in California that has been signed into AB 5 has an exemption in place for online teachers and tutors that are teaching their own curriculum and are not public school tutors. This verbiage is confusing and precludes online ESL tutors from the exemptions because they are not teaching curriculum they create themselves. They are teaching from a company-provided curriculum, which is actually desirable for online tutors because it makes the job easier and they do not work any unpaid hours on curriculum creation. I also would like to tell you a little bit about my own situation. I have depression and anxiety that impacts my traditional employment success. My independent contracting job has allowed me to safely re-enter the workforce while providing the autonomy to manage my mental health in ways employer-employee relationships have not. Thank you again for allowing us to submit testimony today. We hope that you see that any legislation looking to redefine the so-called gig economy should take into consideration the vast implications and devastating economic impact of classifying freelancers with this very broad brush.
Thank you. Right now, if, we heard examples earlier sorry, this is off. We heard examples earlier of workers, independent contractors, even those that work at home. If you're home doing, you do online teaching, correct? If you are in the midst of putting in some time, I'm assuming you do this online?
Yes.
And God forbid you have an accident, you slip and fall out of your office chair and get hurt. What recourse do you have today?
The recourse would be cleaning my house and making sure my chair is safe. That would be on me.
But if you get hurt to the point that you are not able to continue working or meeting your obligations, would you have access to unemployment insurance? Do you have access to workers' comp or any of those other benefits today?
I don't have access to any of those things, but as an unemployed mother, I also do not have access to those things.
The exemptions that were made in the California laws, do you have any sense of what some of the discussions were as to what, I don't know that anybody fought against your exemption necessarily, but because I think you've all raised a good point, right? Clearly, there is no one rule that fits all, and there is always going to be a population of individuals who prefer this option of being an independent contractor. We acknowledge that, or I acknowledge that. What were some of the arguments raised in California to justify your exemption without just me? Because in the description, in particular for the travel agencies, where you described, I think you would have passed that ABC test.
So unfortunately, we would also struggle to satisfy that B prong in California because most of the host agencies also sell travel. The independent contractors that are relying on those host agencies for access to those systems, for the back-end tools that they need to succeed, because they also sell travel, we would be engaged in the same course of business. And so we would have to consider them as employees. And it really is unfair because these truly are people, they market under their own brands, they are truly independent from these host agencies, but because the host agencies are engaged in selling travel and these independent contractors are engaged in selling travel, it's impossible for us to satisfy the B prong. I should note that there are other legislatures, I think this has been mentioned today. New Jersey does currently employ an ABC test, but their B test has 2 prongs. The second prong allows that if you work outside of the usual location of the business, sort of an outside sales exemption, that you can satisfy that B test. So we do have a large number of independent advisors in New Jersey, but they're able to work under the ABC test in New Jersey because they don't work in the physical office location of the host agency that they affiliate themselves with.
Got it. The writers, the journalists, there was an example earlier given of a photographer and their classification. What is it, the same question, like what was the argument? How would you have difficulty meeting the ABC test under the California language?
Well, as I mentioned, the B prong would be the problem for me because I'm a writer, and newspapers and news organizations already employ writers. So that I know in California they did have an exemption where you can do 35 articles per year, and I know a lot of people are having problems with that because in the way writing for the web works, sometimes people meet that in a week or a month. So that would be.
So that threshold number doesn't.
I feel like it's very arbitrary. I'm curious how they came up with that number. I think freelancing is not something you can kind of pigeonhole, freelance writing anyway, like some of the other jobs where you know exactly what you're going to do. You just, I don't know how many stories I'm going to have for a year. I keep pitching and I keep getting assignments, but we don't, you can't really, it's just a very odd number for me to even consider.
So, just to, again, be clear, if we were to go down the road of attempting to legislate our own ABC language, understanding that language may be different and clearer or have more prongs than California language, but you would seek a direct exemption so as to not interrupt the current business model.
Well, I think if you went with an ABC test that did have the 2 prongs of the B test, it largely wouldn't affect our industry because, again, the vast majority of folks that do affiliate themselves with a host agency are going to work in their own homes or their own office shares, those external locations. But if you did go with the narrower B test, like was employed in California, it would be impossible for all of these small business owners to still get the benefits of that easy affiliation, to get the tools they need. And so we would obviously look for an exemption if that more narrow interpretation of the B test was used in New York.
I'm curious, though, that, the ABC test is something that's been around for a really long time, and some other speakers said, why are we using something that's that old in such a new economy? I think that New York should try to come up with something, a third model per se, or something a little more innovative than they just don't seem to fit for a lot of people who work for themselves. Sure, we would love protections and things, but the way the ABC test it's very hard to fit it into the new economy and the creative economy especially.
Well, hence all the exemptions we saw, and but do you want to piecemeal these exemptions? Do you want to? It's just really difficult because every company, every industry operates so differently. There are nuances that I don't think you could ever account for in 3 questions. So, I mean, that is part of the challenge, but I think ultimately it's also creating that balance of benefits and protections for folks who are out working, earning a living, and making sure that, flexibility is important, but so is that the folks have access to those rights and protections that we have afforded and demand businesses to provide in a traditional way, and just adapting to that change. So, but I think you all raise an important point that there is, and particularly your testimony, I appreciate, because it's the voice of somebody who wants this for themselves, and I think that can't be lost in this thought process.
And if I could add, I'm a child of a union family. My father is a retired Local 57 operating engineer. My grandfather was in the union as well. I'm not anti-union. I'm not anti-workers' protections, but I am, trying to save my own job. And I do think that, like the others have said, the ABC test is so narrow, and the types of jobs and the ways people work the jobs in the gig economy, it's really hard to fit in that narrow 3-point test. I'm okay with regulating some industries because some industries are more dangerous than others. I was a little tongue-in-cheek when I said, it's my fault if I fall out of my chair. I provided it myself. But there are, you can't compare my risks to the risks of, someone else who's out on the streets delivering packages or something. It's just not the same. But I do support, I like that AB5 included the online exemption, the online tutor exemption, but it doesn't work for the business plan of these ESL companies where they're giving us the curriculum. So that would exclude the teachers in California. In California, the particular company that I'm with, they have stopped hiring new California teachers. We work on a 6-month at a time contract. I'm on my second contract. January, my contract comes up. If I was a California teacher, I would not know if I would have a third contract.
They stopped doing that even though there was an exemption that included you?
No, the online ESL company is excluded because the online ESL companies give the curriculum. The teachers are not creating the curriculum, so they don't fit that exemption.
Got it.
We're hearing from people who are being turned down for work now based on the proposed legislation in New Jersey, and that's troublesome. Hasn't even been approved yet, but companies are already saying we're not hiring anyone from New Jersey.
And just, again, curiosity, and I'm assuming you haven't encountered this, you seem pretty content with the relationship you have with this particular company.
I love my job.
But have you heard of colleagues who have had wage theft issues associated with some of these companies? Or, there's enforcement there, right? Who would you, if they were not to meet their obligations under your 6-month contract, or use some excuse to end it midway or leave you sort of stranded, what would be your mechanism or recourse for?
I have not heard of that. There are, of course, within the contract, there's stipulations to maintain a good contract. And if a teacher, for example, does not attend classes that they're scheduled for, they say, hey, your contract's under review. And there is a review and appeals process. With the legislations that are happening now, it incentivizes them to be a little less lenient. If there are, something that came up, like I had a sick child and I missed the classes, I can present documentation for, birth of a child or doctor's notes. They're willing to work with you. I have not heard of anyone who had a contract termination without merit.
I appreciate your time.
Thank you.
Thank you.